Good evening, everyone, and welcome to the Brian Crombie Radio Hour on Saga 960. So this is going to be a little bit different tonight. We're going to talk about dealing with your social media life when you die. I think a little bit, and certainly, I think that COVID-19 has impacted all of us, such that some people have talked about how digital expansion that may have occurred over 5 years has now occurred over 5 or 6 or 7 months, and we've become so much more involved in our digital lives, whether they be email or apps or social media or dating apps or virtual meetings and online shopping and banking and everything. And we're joined tonight by Sharon Hartung, who is a member of the Society of Trust and Estate Practitioner. She's an affiliate of the STEP Global Digit Asset Special Interest Group, and she's an author of a fascinating book called Your Digital Undertaker, Exploring Death in the Digital Age in Canada. She's the founder and principal of Your Digital Undertaker, which is a consulting practice that deals with the estate sector and issues in regards to digital assets. I'm going to go through a little bit more of her background maybe later because it's absolutely broad and fascinating. But Sharon Hartung, welcome to our show. How are you?
Thanks very much, Brian. Delighted to be here. And you're right, the digital topic has definitely taken off. And look at us, we're talking virtually in a way we probably wouldn't have talked about a year ago.
How did you get involved in being the digital undertaker?
Well, it's an interesting story, and it didn't start with technology like you might think, because that was my background. It started simply and personally because my mom died without a will. And so I got involved with dealing with her estate, trying to figure out all the things that happens when you deal with your estate. And as I went through the process, I realized, wow, this is a pretty big job for the executor. And we're talking even without dealing with our digital lives. In fact, she had a pretty small digital footprint. It was only one email address. And as I went through her estate and realized it took me almost 2 years to settle it, dealing with just her physical life and property. And at the end of the process, I thought, I got to take everything I've learned through this journey and get it into a book for the digital age, given now the fact that we are immersed in technology. And when I reflected on my own self, I didn't have a paper trail that my mother left me. I have a digital trail, and what was going to happen to that.
And so this book, it takes you through all the problems, issues, and steps on how to solve them?
Well, to take into consideration what we should do with our digital lives. So how do we deal with social media? How can we plan for that? How do we deal with our now potentially cryptos? How do we deal with our digital photos? We really have to understand about our will and estate plan. So the book takes you through every aspect of estate planning from a very practitioner's viewpoint, from a layperson, from a daughter like myself who had to deal with my mother's estate. So it takes you through what's the job of the executor, how important the will is and where to get one. Taxes come into play, philanthropy and gift planning. So it takes you through the spectrum so you can understand the basics of our life from a physical asset perspective, and then it layers on our digital lives. So once we understand the basics, then it's a real deep dive into considering what our digital footprint looks like, from social media to the fact that we use email. Everyone uses email. Over 70% of North Americans use Facebook, for example. How do we deal with those kinds of things? So I get into pretty deeply in chapter 7.
So this book is about being an executor of physical assets as well, not just the digital assets, but then you add on all the issues in regards to digital assets. Is that correct?
Correct. It's the book for executors to ask the will maker and testator while they're living. So in the past, we would know that it's important to get a will. We would probably go to a lawyer or a legal advisor or get some legal advice and get one done. We'd probably leave it somewhere and not talk to our executor. In the digital age, we have a real possibility of losing everything, even our paper, even the trail to our physical assets. So the executor has a really important job to do as running a project and shutting down someone's life. And the only way to know where to find everything is to have a conversation in advance. So this book is all the questions the executor should ask the will maker, where things are. Do they use social media? Do they have online banking? Where do they find the stuff to do their jobs, because there's no paper trail?
And if people are interested in this book, how do they get it?
Lots of places you can get it. You can get it on Amazon. You can get it from my website, Your Digital Undertaker. You can actually get it at the libraries. I've been donating the digital book to libraries. So if a Canadian library wants a copy of the digital book, they just reach out to me. We can get it uploaded. So lots of spots to find it.
We're chatting tonight with Sharon. How do I pronounce your last name? Hartung? Is that correct?
Hartung, as in heart lung, Hartung.
Hartung, who is the author of the book, Your Digital Undertaker, Exploring Death in the Digital Age in Canada. We're going to take a break for some messages to come back more with Sharon and explain, as she explains some of these issues for us. Stay with us. Welcome back to the Brian Crombie Radio Hour. We're talking tonight about what you got to do before you die, when you're alive, with an executor in the creation of a will to deal with your virtual digital life. And we're talking to Sharon Hartung, who is the author of Your Digital Undertaker, Exploring Death in the Digital Age in Canada. She's actually really kind of interesting because she's got a very broad background. She is a retired captain and aerospace engineering officer with the Royal Canadian Air Force. So that would be completely separately an interesting conversation. She's a former technology executive and consultant with IBM Global Services. She has a Master's of Science in Management Information Systems. She's a project management professional certificate, and she's a professional engineer. So you're pretty smart, obviously, and you've got a pretty broad and interesting background. Let me ask you, you said you got into this because of your mother's passing and you had to deal with all of her stuff. I had an uncle that passed away, a favorite uncle that passed away, and he had a Facebook account that my daughter, his great niece, had set up. No one could remember the password for it. It was a beautiful Facebook because it had a bunch of pictures and it had notifications that would pop up of the day of his passing, of his birthday, the anniversary of his marriage, etc. But, you know, everyone thought that we should close it down after he passed away, even though frankly, I liked it because, you know, it was a nice way to remind us of him and his life and some of the important days in his life. What do you do with things like Facebook?
Well, as you point out, we use a lot of social platforms to share information, communicate, and share mementos and things that remind us of our loved ones, which are pretty important. And Facebook's pretty popular. As I mentioned, 70% of North Americans use Facebook. People share lots of content and photos on Facebook. Now, Facebook is one of the two big tech giants that have started to contemplate some of these estate planning requirements. So Facebook specifically has some choices you can make in advance while you're living. You can appoint a legacy contact. So this will someone that will, in effect, curate your site after you pass away. You have a choice of memorializing the site or having it deleted. And then they have also introduced a new feature called Tribute, where you can share family members and friends and others can share information after and share wishes, etc. after you've passed away. So what's really important is the fact that people need to become aware that these choices are out there that they can make. If you don't set up legacy contact, and if you don't make choices like memorializing or deleting the account, the only choice that really exists in most social media, we're talking LinkedIn and Twitter and all the other platforms like Instagram, you can contact just about any company and shut an account down with a simple form that they have with an obituary link. But if you want those memories to remain for others, we need to make some other steps to do so. It's pretty easy with Facebook. You just search on help and look for legacy contact and memorialization and click some choices and make a choice. So it's pretty easy to do, but we need to be aware that those choices are out there so we can make those kinds of choices as well.
All my banking, my income tax, so much of my life is now in my computer or online. And I would have thought that, in the past, it could have been accessible to my executor, but now it's all digital. How do you deal with that?
Yes, the digital trail to our lives is now online through us, as you suggest. So that poses a real challenge to our executor or estate trustee in terms of a traditional job is to walk into your home office and find the paper trail, find the statements that you had to know what you owned, and then go to those institutions and provide the documentation that's required legally. But today, if you walk into a home office, you're going to be faced with a screen and likely with a password on it, and you're not going to know what someone has. We renew our insurance now online through our email. So what's pretty important today, it's been a longstanding advice by estate planners, is to leave some information to your executor and have a conversation with them. Some people call that an inventory. I call it a paper folder or box or list. Doesn't have to include totals of how much you have in your various accounts. Doesn't even need to include the account number, but you need to give the executor somewhere to go, because they won't know what online banking that you do, etc. Now, it's also important that the executor should not be logging into your accounts after you pass away. That violates the terms of services in some countries. That's against the law as well. They should go to the institution that you dealt with the documentation that supports their role, like your probated will and your death certificate, and walk through the process. As the industry digitizes, those things are probably going to be done online as well in the future. So that paper trail to what existed in your life, as you point out, your bank accounts, etc., is now digital, and the executor is going to need to know what you have.
So tell me about the process of a will and a probated will, if you could.
Sure, absolutely. A will today is a paper document that's signed, and there are requirements in each province in terms of what's considered a legally valid will. There's new legislation coming where people are discussing the opportunity for us to have legislated electronic will. So that's another conversation for another day. But today it's a paper will, and it has signed original copies. So the executor is going to need to know where your will is stored, or where is it, so they can get it. Once you pass away, the executor finds that document and then goes through a process of getting it recognized by the courts. And probate is a legal community refers to the process that's set out by the courts in a specific jurisdiction in terms of how they validate that is a legally valid will. And you get an associated document or stamp that goes with that bill. You take that then documentation to various institutions or organizations that you deal with to access the deceased's assets, and then deal with it as the will directs.
How long does a probate process take?
It completely depends on the province and sort of the queue that goes on in the province. So it completely depends. For myself, when I was going through my mother's process, it took me almost 9 months to be appointed as her executor and get the probate document. So it completely depends.
And so you say that someone should not have access to all of your old email systems and online banking, etc. So what, you got to print it out, or they got to take the probated will to the bank to get access to all that information? That seems a little bit cumbersome.
Well, there's a lot there, and what you have digitally could be quite large. So what I recommend advisors do with their clients, and this is good advice for everyone, is consider the top 3 digital assets that you would be devastated if they were lost. If your digital photos are really significantly important to you, today the entire industry is trying to come to terms with how to deal with our entire digital footprint on death. And for now, it means you may have to look at some backup mechanism. Perhaps there's some sort of, if you think of digital photos, perhaps you can do digital photo sharing. Perhaps you can even print them out, or maybe even in the future, the company will consider providing options where you can share the photo. It's a big job being an executor, and we have a lot of things more so than we did 10 or 20 years ago, including our digital footprint. So there's a lot we need to do. I often recommend we just start with a simple list of the top things that you would be devastated if you lost, including your physical things, and then grow the list even bigger if you can at that point.
Do you recommend people appoint a lawyer as an executor, or a friend or a family member?
It completely depends on a person's personal circumstances. In the book, I talk about the different options that are available. It's going to depend on how big your estate is, how complicated you want to do things, and there's lots of different variations depending on your circumstances to choose. Like you say, you can pick a family member, you can pick a family member and a fiduciary, another kind of fiduciary, you can pick a trust company. So there's lots of different options that an estate planner can help you select.
The other issue that comes up a lot is living wills. Can you explain what a living will is?
Well, I'm not a lawyer, but I can tell you from a practitioner perspective what I know about them. We don't generally use the term living wills in Canada. It's more an American term, but what it does refer to is documents that you want in place to look after you while you're living. And there's 2 main documents. Each province has a different term for them, but you'll recognize them as a power of attorney for your financial affairs, in which you appoint someone to be able to handle your financial affairs if you become incapacitated. And then there are advanced care plans or advanced care directives or representation agreements where you appoint someone to look after yourself if you become incapacitated and make health decisions. So there's kind of two documents while you're living that look after you if you become incapacitated, and then the will kicks in after you become deceased.
I understand that your mother, when she passed away, and my condolences on her passing, passed away without a will. What's the challenge of that if a loved one does not have a will?
Well, it does pose a lot of challenges. The first challenge that I faced, which most people will face, is that someone will need to be appointed by the court to act as the executor. So that's a process of, and every province has a set of jurisdictions that specify who is allowed to apply to the court. So that takes time. Then the second thing that happens is that you no longer can honor the individual's wishes because they don't have a will. So the court and the court processes decide who gets what. And that's laid out in legislation in each province. There's a bit of a formula on who gets what. And in this new area of digital assets, what becomes even more complicated is that based on the way the laws are evolving in the US with respect to our large tech giants, you pretty well need to document your wishes on what you want happen to your digital life for them to be honored. So right now there's a gap there. So and even the legislation hasn't been implemented to deal with that completely. So your digital life will end up becoming just orphaned if you don't have a will and take care of it.
What do you mean your digital life will become orphaned?
What I mean by that, in the US, they've implemented what they call fiduciary access laws. What an executor is allowed to do in the US, and the laws in the US, where most of the tech giant sits and most of the technology that we use, is based on the fact that you must have a directive in place while you're living that gives someone the right to access your digital assets after death. And that can be done in a number of different ways in which a legal advisor can guide you in terms of dealing with that. But one of the things that you can do is get a digital asset clause put in your will that gives the executor powers to deal with your digital life. Now, we haven't tested yet, as far as I can tell in the case law, in terms of a digital asset clause in a Canadian will. Will that work with the US tech giant? We don't know yet. That's why I continue to recommend people use the pre-planning tools that are offered out there. The one I mentioned earlier, Facebook, and also Google has an inactive account manager where you can appoint someone to get access to your email.
What if someone has got some embarrassing photos and they don't want anyone to access them?
Those are what you want to happen to your digital life, even as specific as an account, even as specific as photos. Those are wishes and directives that you can give to a legal advisor and get incorporated in your will or the proper instruments to say what people can and can't do. But as you point out, Brian, it's important for people to figure out what they want and write it down so that it can be adhered to after they pass away.
So bottom line is you're saying, think about it. And probably appoint someone to take care of it and give them direction as to what you want to have them to have access and to continue to exist versus what you might want to just sort of go away with you.
Absolutely. It can seem like an overwhelming task, and a lot of people don't want to talk about death and wills, but it's pretty well today dealing with your digital life. You're going to have to put some paperwork in place and leave an inventory for your executor and have a conversation with them. Absolutely.
What other suggestions have you got in closing to tell us in regards to how we deal with our digital lives?
Well, if I was to summarize the 5 things, seek some legal advice and get a will. We know that less than 50% of Canadians don't have a will, so this is a terrific time to get one that includes not only your physical life, but now includes your digital life. And what's important, as I mentioned earlier, is what a will does is give the executor powers to deal with your digital life. If you don't have a will, like I said, this is a great time to get one and get your digital life included in it. Create an inventory of what's important. The Society of Trust and Estate Practitioners that I'm part of has an inventory for digital assets, digital accounts, and digital devices. Any advisor in the financial sector, insurance sector, or estate planning sector can get a copy from STEP and give it to clients. If you don't want to do something so complicated, just create a list of those things that are important to you, take a notepad out and get them done. Number 4, I'd say prepare the executor. They're not going to find your paper statements in your home office anymore. They need to know what you own and what you'd like done with it. And the fifth and last thing is, one of the best things you can do for your family is leave memories for your loved ones. So we used to have, letters and physical photo albums. Now that stuff is all digital. So think about how to leave some of that behind.
And remind us of how we can get your book if we're interested.
Thank you for asking, Brian. Absolutely. You can get it on Amazon by searching Your Digital Undertaker. You can get it on my website at yourdigitalundertaker.ca.
Sharon Hartung, author of The Digital Undertaker, sounds like a pretty important book that some of us should be considering before we get a little bit too old. Lots of people talk about that you gotta face the reality before you get too old. And I think this is probably one of the realities that we've got to consider that we haven't thought about before. So thank you very much for raising the topic with us and educating us about it.
Thank you, Brian. Appreciate the invitation.
We're going to take a break and come back more in just a minute. Stay with us.